Hello, I'm Jenny Kiffmeyer, and I'm here today to share with you some fiduciary hot topics that you can talk about with your plan sponsor clients. Starting off our topics, we have President Biden's fiscal year 2025 budget proposal. Now, just to give you a little context, the government runs on a fiscal year starting 10/1 and running through September 30. So the fiscal year 2025 will actually start this coming October. Now, keep in mind that the budget proposal is the first volley of suggested policies coming from the current administration. These are just preliminary ideas. They have not been introduced as bills at this point and may never be introduced as bills, but these are just kind of the first set of ideas coming out. And what we wanted to highlight in this year's budget proposal applies primarily to high income taxpayers, or HITs, as I have abbreviated them. And these are individuals with high income, adjusted gross income of $450,000 if they're joint filers, $425,000 if head of household, and a single filer would be $400,000. And these provisions really are targeted at individual investors. However, what these would do is cap all retirement savings at $10 million. And in order for the government to know that, where the impact to plan sponsors comes in is that DC plan sponsors would be required to annually report participant account balances to both the IRS and to the participant, so that they would know when they're approaching the limits. And in fact, they have to report these if balances exceed $2.5 million. Now, as I said, this is just a preliminary idea. There's no detail yet on how to report to the IRS or to the participant. So that would be forthcoming if, this were ever to become a final bill and enacted into law. The likelihood of that happening is slim. But it's interesting to note that these ideas, in fact, this kind of same limiting or capping of retirement income, or excuse me, retirement plan account balances comes up routinely. And so it's something that remains on the minds of the administration and Congress members. Moving on to this next bill that I wanted to highlight. It's the Social Security Fairness Act of 2023. Every year, there are hundreds of bills addressing the Social Security Act and changes to Social Security. And we all know that Social Security is going to need some kind of changing in order to stay, in available for generations to come. This bill in particular is just another individual investor bill. But it is good to know for plan sponsors to know about it because they may get participant questions. And if they do, the best place to send participants is to the Social Security Administration website or the Medicare website. They have a great FAQ available on both of those sites for questions related to Social Security and Medicare. In particular, the Social Security Fairness Act would do away with what's called the government pension offset, as well as the windfall and elimination provisions. And these are provisions that, up to this point, require a reduction in benefits if they participate in a government pension or an employer who has not withheld Social Security taxes. So again, this is only a bill at this juncture, not a law. So just keep aware that this is something that might come into play, and the best source of information is the Social Security Administration website as well as the Medicare website. Now we'll move on to the final DOL investment advice fiduciary rule. And you have no doubt heard, seen, read volumes on this already because it has been a very hot topic. We do have final rules in place now that will define a person as a fiduciary if they provide advice for a fee to quote unquote a retirement investor. Now, a retirement investor would include a plan sponsor, as well as plan participants or IRA owners and beneficiaries of both plans and IRAs. What is changing, and I'll just give you just a short, brief background. What's changing is the use of the specific test for determining whether a person is an investment advice fiduciary. We used to have the 5-part test. Now, under the final rules, we have the 3-part test. And it really comes down to those 3 parts being number 1, if an individual provides investment recommendations to one of those retirement investors, that person receives a fee or other compensation for that recommendation. And thirdly, if that individual giving the advice either states that they are a fiduciary, or if the person receiving the advice feels that that person is a trusted advisor making a recommendation that's individualized to the person based on that individual's best interest. So those 3 criteria would lead that person giving a recommendation to be an investment advice fiduciary. Now, this new regulation doesn't go into effect until September 23rd of 2024. However, there's been a number of lawsuits filed challenging the regulations. There's also been a Congressional Review Act resolution that just passed yesterday, one of the House committees, and now will move to a vote in front of the full House, that also would disapprove of this regulation. And so we may see some kind of reversal or change in this final rule pending the outcome of these court cases and this Congressional Review Act filing. So why this matters to plan sponsors is that it is something that you'll need to be aware of on a couple of different levels. It would concern the plan sponsor when picking plan service providers, in that certain call center operators that are discussing plan distributions or rollovers, et cetera, investments within the plan could be seen as investment advice fiduciaries under this new rule. And so because it is a responsibility of the plan sponsor to prudently select plan service providers, this would carry through as a responsibility of the plan sponsor to make sure that that service provider is somehow meeting a prohibited transaction exemption that would allow them to provide this type of advice. So that's one level. Another level is that the plan sponsors themselves are actually or could actually be the beneficiaries of this investment advice, because the advisors that are giving guidance to plan sponsors regarding investments are investment advice fiduciaries. And so that could cause some of the increases in costs for investment advice, because more providers may decide not to give advice, which could cause increases in the cost of investment advice out there. So something the plan sponsors could be facing with respect to these regulations. As I mentioned, time's kind of running out to see, the challenge on these regulations. One thing that might come into play, and this is something very new. In fact, it was just approved by the Supreme Court June 28th. The ruling came through from the Supreme Court that does away with something that's called the Chevron document. And the Chevron document was something that has been in place since 1984. And what that doctrine said is that any federal courts that were reviewing regulations, if they found those reviewing statutes, if they found those statutes to be ambiguous, the courts then could turn to how various agencies were interpreting the statutes through their regulations, and then consider those interpretations in their rulings. Now, as a result of the Chevron doctrine being reversed, federal courts looking at these statutes must make the determination on their own using their independent justice judgment and would not then defer to any interpretation by the regulatory agencies. So, for example, before the Chevron, or when the Chevron doctrine was in place, the courts could look to the Department of Labor and how the Department of Labor was interpreting a particular statute and regulation. Now that Chevron doctrine is gone, they would no longer look to that interpretation and determine it on their own. So it could come into play in the cases that are pending against the fiduciary regulation. So as Yogi Berra said, it ain't over till it's over. And so we'll continue to watch this very closely. We'll move on now to our next topic, which is Notice 2024-35. And this relates specifically to what's something called specified RMDs. Now, if you recall from this first Secure Act, we had a change in beneficiary distribution rules that said that certain non-spouse beneficiaries would be required to distribute assets from either a plan or an IRA over a 10-year period. They no longer could stretch out distributions over a lifetime. Now, what has happened is that with that change in Secure Act, these beneficiaries, these non-spouse beneficiaries, have to deplete the accounts within 10 years. However, there was confusion as to whether or not the beneficiaries had to take at least a minimum distribution each year and then deplete the account in the 10th year, or whether they could wait until the final year, the 10th year, and take the entire amount out at that time. So because of that confusion, the IRS issued this relief, and it's been issued annually since 2021. And this year we have it for 2024 as well. And the relief says that if an individual who is required to take one of these distributions failed to take it, or if a plan failed to distribute that specified RMD, there's no harm, no foul. There's no penalty to the participant, and the plan is not at any risk of, failing to operationally comply with rules. So we have that relief under Notice 2024-35. Moving on to another topic, the environmental and social governance investing. We do have final regulations on ESG investing, how plan sponsors should approach incorporating ESG type investments into a plan. So the impact is really, how do plan sponsors consider these ESG factors? And the bottom line is that ESG factors can be considered if they are relevant to the risk and return analysis of the investment. So first and foremost, plan sponsors, when they are selecting plan investment options, have to evaluate the risk and return analysis, making sure they're focusing on that, and then they can consider ESG factors for making a final determination. There's been court cases again filed against ESG investing, and here again we may see that the reversal of the Chevron doctrine come into play here, where federal courts would be required to just make the determinations or the rulings based on their own judgment and not considering any of the agency's interpretations. Moving on to our defined benefit risk transfer. As you can well imagine, this applies strictly to defined benefit plan sponsors, and it comes into play in cases where a plan sponsor is de-risking their plan or reducing their liabilities. And one way to do that is to go outside of the plan and purchase annuities from an insurance provider, purchase annuities to guarantee the benefit payments for participants within the plan. That's called a buyout. You may have heard of that phrase. The Department of Labor issued an interpretive bulletin years ago, 95-1 in 1995, that lays out specifically the criteria that plan sponsors must follow in order to prudently select an annuity provider for this pension buyout or this risk transfer. And so the impact for plan sponsors is to carefully follow the provisions of Interpretive Bulletin 95-1. Um, of note is the fact that the DOL is considering rewriting that interpretive bulletin. So we'll need to keep our eyes and ears open for any developments on whether the DOL does choose to reissue a new interpretive bulletin. But following the provisions of 95-1 and documenting how a provider or how a plan sponsor chooses the annuity provider is a great way to have fiduciary protection should there ever be any question. And our final topic is cybersecurity. I just thought this was an interesting, very interesting case. Cybersecurity is a hot topic, not only in the retirement world, but basically across all the financial sectors and personally as well. In this particular case, it did involve a union plan, and it was an $8.7 million settlement. Now, that means that the plaintiff agreed to pay $8.7 million to the class action participants. And because they paid that amount, then they did not have to admit any wrongdoing. But what happened was there was a cyber attack on two servers hosting these union plans, and the data breach allowed sensitive PII, personally identifiable information that you've heard so much about, was breached. And so hence the class action lawsuit. Now, the impact of plan sponsors, there's a couple of things. There's increasing scrutiny in Department of Labor and IRS audits with respect to cybersecurity. The Department of Labor has identified cybersecurity as a potential examination area. They haven't launched investigations specifically yet for cybersecurity. However, for those plans that are already under audit or being examined, the examiners are asking for information, extensive information regarding how the plan sponsor is handling their security processes and procedures, as well as how the plan service providers are meeting the expectations of keeping that PII, that sensitive information, confidential. Right now, we do not have any Department of Labor regulations or statutes, et cetera, that define how to protect participant information. We know that it is required to keep that information secure, but we don't have the roadmap necessarily on how to do that. The best that we have are three documents, three best practices issued by the Department of Labor. One is written for service providers and what they need to do to provide, to put in place the proper procedures and, checks and balances to keep information safe. There's a separate document for plan sponsors to review, to look internally to their payroll departments and how they interact with their service providers in order to keep information safe. And then the third document is written specifically for plan participants. The best practices for a way for participants or individual investors to keep their information safe. Again, these are best practices, but they're a great way to start implementing and at least, following these and documenting how you are putting in place these cybersecurity protection provisions is a way to mitigate your fiduciary liability. And I'd like to point out that just in research that I've done, a number of articles have pointed to the weakest link in cybersecurity breaches as the individual, the plan participant. And I can say for myself that I am a guilty party in not keeping and not changing my passwords as I should, or setting them up under appropriate protocol. So that third document for plan participants would be a great way to host a participant education session and pass that out, go through those, the steps, and then document that for your fiduciary file as a way to demonstrate that you've helped at least educated participants on how to protect their personal information. Well, thank you for participating. That's the rundown of this quarter's headlines, and I certainly look forward to sharing next quarter's hot topics with you.